Hello, I am Professor Shraditya Rakshit. The module is Inter-American System Protection of Human Rights. This is module 33A. To understand the American system for the protection of human rights, to have a comprehensive view of the various conventions and instruments, the Inter-American System for the Protection of Human Rights is the world's major regional human rights system. It promotes and monitors the implementation of the human rights obligations of 35 member states of the Organization of American States, in other words, the OAS. The American Declaration of the Rights and Duties of Man and the American Convention on Human Rights and its protocols to the abolishment of death penalty, prevention of torture, enforced disappearances, and discrimination against disabled persons, and prevention of violence against women. It is to be kept in mind that there are two main human rights. And when I say human rights, I mean human monitoring bodies in USA. And these are as follows. One is the American Court of Human Rights, and the second is the Inter-American Commission on Human Rights. Now, both bodies receive complaints and issue emergency and proactive measures. The Organization of American States is a regional intergovernmental organization as defined by Article 52 of the UN Charter. The OAS Charter was adopted at the 9th International Conference of Co-American States in 1948 and entered into force in 1951. The 1967 Protocol of Buenos Aires changed the structure of the organization in several aspects and elevated the status of the Inter-American Commission on Human Rights to that of a principal organ of the OAS. Article 3, Clause J of the 1948 Charter referred to the fundamental rights of the individual. Among the principle which the Charter however, doesn't list or define the human rights it refers to. The Inter-American Court has ruled that these rights are none other than those enunciated and defined in the American Declaration. The General Assembly composed of representatives of the 35 member states. This General Assembly is the supreme organ of the OAS Assembly. It shall decide the general action and policy of the organization and elects the members of the Inter-American Commission. Now, the judges of the court are elected by the state parties to the American Convention on Human Rights. The Permanent Council is composed of one representative of each member state of the OAS with the rank of ambassador, which is Article 80 of the OAS Charter. It reviews the annual reports of the Inter-American Commission and the court. After discussing the court's annual report, the General Assembly may consider only the resolutions which are approved by the Permanent Council. It is to be kept in mind that the meetings of consultations of ministers of foreign affairs are basically in the nature of ad hoc meetings held at the request of any government whenever problems of an urgent nature and of common interest to the member state arise. The General Secretariat is the central and permanent organ of the OAS in Washington, D.C. It performs the functions assigned to it in the Charter, that is Articles 112 and 113. In other American treaties and agreements and those entrusted by the General Assembly. The meetings of consultation of ministers of foreign affairs or the councils of the organization. The American Declaration of the Rights and Duties of Man and also the American Declaration of the Rights and Duties of Man, ADHR, on 2nd May 1948 was adopted as a non-binding instrument which is nowadays deemed to be the authoritative interpretation of the fundamental rights of the individual, which Article 3J of the OAS Charter proclaims as one of the principles of the organization. The Inter-American Court confirmed the legal force of the American Declaration. This is an advisory on the interpretation of the American Declaration of the Rights and Duties of Man. This is within the framework of Article 64 of the American Convention on HR. The Inter-American Commission receives individual complaints alleging violations of the Declaration with respect to OAS. The OAS member states that are not parties to the American Convention on HR. The ACHR was adopted on 20th November 1969 and entered into force on 18 July 1978. The major OAS member states had ratified the convention with the notable exception of the USA and Canada. And in 2012, Venezuela denounced the convention. The Inter-American Commission on Human Rights and the Inter-American Court of Human Rights is legally binding only on the state parties which are parties to the agreement. The ACHR contains primarily civil and political rights. Article 26 expresses the general commitment of states parties to adopt measures with a view to the full realization of economic, social, and cultural rights. ACHR differs from the ICCPR because it contains guarantees of the followings, which are A. To reply, Article 14, to property, Article 21, to right to participate in government, Article 23, the right to equal protection, Article 24. The Chapter 1 talks about general obligations. Obligations to respect rights is Article 1. Domestic and legal effects is Article 2. Chapter 2 talks about civil and political rights. Article 3, which is judicial personality and right to life, is Article 4. And then there is right to humane treatment, Article 5, and freedom from slavery, Article 6. And there is right to personal liberty under Article 7. Right to a fair trial, Article 8. Freedom from law, Article 9. Right to compensation, Article 10. Right to privacy, Article 11. Freedom of conscience and religions, Article 12. Freedom of thought and expression, Article 13. Right to reply, Article 14. Right to assembly, Article 15. There is also freedom of association, which is Article 16. Rights of the family is Article 17. Right to a name, Article 19. And the rights of the child, Article 19. Then there is right to nationality, Article 20. Also with it is right to property under Article 21 and freedom of movement and residence under Article 22 and the right, most essentially, to participate in government, Article 23, and right to equal protection, Article 24, and right to judicial protection, Article 25. Chapter 3 talks about economic and social and cultural rights, Article 26, and Chapter 4 talks about suspension of guarantees and the interpretation. Chapter 5 talks about personal responsibilities, Article 32, and Chapter 6 talks about competent organs, Article 33, and Chapter 7 talks about Inter-American Commission on Human Rights, Articles 34 to 51. And Chapter 8 talks about Inter-American Court of Human Rights, Articles 52 to 69, and Chapter 9 talks about common provisions up to 70 to 73, and Chapter 10 and Chapter 11 talks about general and transitory provisions, Articles 74 to 82. Protocol of San Salvador in the area of economic, social, and cultural rights. The Protocol of San Salvador was adopted in 1988 to give effect to Article 26 of the American Convention of Human Rights, ACHR. It entered into force on 16 November 1999 and its protocol had 16 signatory parties. The state parties to the protocol undertake both domestically and through international cooperation, especially economic and technical, to save progressively and pursuant to their internal legislation. It does so in the full observance of the rights which are recognized in the protocol. Progressive implementation is nonetheless an obligation. The Protocol of San Salvador is in the area of economic, social, and cultural rights of 1988. This protocol contains mostly the same rights as the ICE-SCR. The protocol establishes the possibility to submit to the Inter-American Commission through the individual petition mechanisms complaints alleging violations of the rights to organize and to join unions and national federations of unions, or in other words, international trade union. These can be organizations and they can be protected under Article 18 Clause 1, Subclause A, as violations of right to education protected under Article 13. The court may examine these cases under its contentious jurisdiction by the virtue of Article 19, Clause 6. Then there is an important protocol, that is the protocol to abolish the death penalty in 1990. This protocol was adopted on 8 June 1990, Article 4 ACHR, Right to Life. No reservations may be made to the protocol. This protocol reserves the right to apply the death penalty in wartime in accordance with international law for extremely serious crimes of a military nature. This exception must be provided for in domestic law, and its application is subject to strict guidelines and reporting conditions. And these conditions are set out in the protocol. Then there is the Inter-American Convention to Prevent and Punish Torture, 1985. The Convention on the Torture was adopted on 9 December 1985 and it entered into force on 20th February 1987. It expands upon the provision of Article 5 of the ACHR, which prohibits torture and cruel, inhuman, or degrading punishment or treatment and can be invoked. The Inter-American Court to interpret the provisions of Article 5 ACHR. Furthermore, the Court has given itself jurisdiction to apply the Convention directly, suspension of constitutional guarantees, and undertakes to submit reports on any legislative, judicial, administrative, as well as other actions. Then there is the Inter-American Convention on the Forced Disappearance of Persons of 1994. Adopted on 9 June 1994, the Convention on the Forced Disappearances of Persons came into force on 28 March 1996. Plagued Latin America for decades because such was the phenomena of forced disappearance. Now, what is a forced disappearance? A forced disappearance is when a person is secretly abducted or imprisoned by agents of the state or others acting with the authorization, support, or acquiescence of the state, followed by an absence of information or a refusal to acknowledge that deprivation of freedom, or to give information on the whereabouts of that person, thereby impeding his or her resource to the applicable legal remedies, as well as procedural guarantees. The Convention stipulates that parties should punish those who commit or attempt to commit the crime of forced disappearance. This forced disappearance of persons, and cooperate with one another to prevent, punish, and eliminate such possibility of disappearances. Violations of the Convention can be brought to the attention of the Inter-American Commission and follow the same process as petitions under the American Convention. Then you have the Inter-American Convention on the Prevention of Punishment and Eradication of Violence against Women Convention. This is known as the Convention of Belém do Pará of 1994. This convention was adopted on 9 June 1994 and it came into force on 2nd March 1995 based on gender issues which causes death or psychological harm or suffering to women, whether public or private sphere. The definition of violence also includes domestic violence and violence in the widest sense, within any interpersonal relationship, whether or not the perpetrator resides with the victim, violence occurring in the community, or perpetrated or condoned by the state or its agents. Wherever it occurs, state parties have specific duties under this convention. This convention is to adopt the required legislative measures to prevent and punish all forms of violence against women. Inter-American Convention on the Elimination of All Forms of Discrimination against Persons who are suffering with disabilities. This was in 1999. Adopted on 7 June 1999, this convention entered into force on 14 September 2001. The convention is divided into 4 parts. The objectives concerning the prevention and the elimination of the discrimination and the integration of persons with disabilities into society, the obligation of state parties, and the definition of discrimination and disability. Further, implementation mechanisms. The Convention establishes a supervisory mechanism. The supervisory mechanism is nothing but the Committee for the Elimination of All Forms of Discrimination against Persons with Disabilities, composed of 1 representative from each state party. The committee is charged with reviewing state reports to be submitted every 4 years on follow-up on the commitments. These commitments are undertaken in the convention. The Inter-American System for the Protection for Rights or Human Rights is the world's major regional human rights system. It has protocols on economic, social, and cultural rights. It has conventions on the abolishment of death penalty, prevention of torture, enforced disappearance, discrimination against disabled persons, and prevention of violence against women. Thank you.